Morning. I'm Mark Ellinger. I'm the Vice President of the Jefferson City Chapter. As we would ask our next panel to come up and take their chairs, and I think Judge Benton has an outline for where everybody's supposed to sit, so I'll let him organize everybody. A couple of very quick housekeeping announcements. First of all, please don't forget to scan the QR code at the back of your program to get your CLE credit. There's also a link at the bottom if you prefer not to use the QR code. You can type in and get your credit. And then also after this panel, there'll be lunch downstairs on the second floor. Those of you who made it to the Secretary's office for the breakfast, seeing the tables down there, that's where the lunch will be also. So, okay. We got everybody organized now?
No, we're organized.
So I get the honor of introducing the moderator of this panel, which is probably the most esteemed person that I get to ever introduce. I go way back with Judge Benton. We have an agreed upon, I won't embarrass him and he won't embarrass me because we go so far back. I think Harvey probably goes even farther back and can tell even better stories, but he's back there, so we don't have to worry about it. So Honorable Judge Duane Benton is on the 8th Circuit Court of Appeals. In July of 2004, he started serving in that, so that's 18 and a half years now. He spent 13 years on the Missouri Supreme Court right here in Jefferson City. He was the president of my Rotary Club. He was Rotary District Governor. You got all that great stuff. We won't get into all that. But it's the long and short is, Duane's kind of done just about everything a lawyer could want to do in their career. And it's not too bad from a kid who grew up in Willow Springs, right?
Yeah. Sure.
So it's my pleasure to introduce the Honorable Judge Duane Benton.
Yeah. Well, I wonder what did it. Does anybody know what did it? I don't know. I'll try again. That worked. We have an IT person here, so there won't be sabotage, a person from the Federalist Society. Well, first of all, most importantly, we'll end before noon for lunch. Okay, so don't worry about, applause for that. Is County Executive Ailman still in the room? Yeah, there he is. Now, I've got to say, and I'll be very quick, that if you need to know where any bodies are buried here, he served in this chamber for several terms, then was Republican leader, many of you know, in the Senate for several terms, then a judge for a while, and now he's this county near St. Louis that he's involved with. So let's talk about this panel. Rather than do introductions, and I threatened Mark, whom I have known since he's a little kid running around in short pants in the backyard, but I threatened Mark if he said very much, because we want to begin with path to the bench. Many of you out here should be judges, are judges, or should have been judge. Right. And so we wanted to start with talking to you and have each judge, and that will be their introduction, talk a little bit about their path to the bench, and I challenge them to talk generically but plainly about that. And we'll begin with Judge Torbitsky.
Hey, good morning, everybody. I'm John Torbitsky. I'm on the Court of Appeals for the Eastern District of the state of Missouri. My path to the bench, I guess, it was probably maybe one of the shortest of everybody up here. But coming out of law school, I was fortunate enough to get a job clerking for Zell Fisher on the Supreme Court of Missouri here. And doing that was just something that, you really kind of get into the nuts and bolts of the law, and you get to see an appellate judge at work. And so coming out of that was just something that was really interesting for me that really got me to where I knew that's what I wanted to do. And so I left Judge Fisher. I went into private practice. I worked for some civil defense law firms in the city of St. Louis. And I got a call one day from Zell, and he asked, "Hey, do you want to start applying for this?" And I said, "Yeah, I think, he had to ask me how old I was first, just to make sure that I was constitutionally eligible to serve." And then after he did that, I said, "Yeah, if you think the time's right." And he said, "Well, you just do it when you need to do it." And so I started applying and went through the process, and was fortunate enough. I made a panel my first time putting in with Zell as the Chief Justice, It took me a couple more times. I made it my 5th panel. They got to keep applying, they say. It's a process. And then after that, I made my 5th panel and was fortunate enough to get appointed by the governor. So,
Thank you. Survive the Missouri Plan. At this end, Judge Stevens, path to the bench.
Thank you, Judge. Chris Stevens, also on the Court of Appeals in St. Louis, the Eastern District of Missouri. Judge Torbitsky is humble. I will tell you, he likes to remind me, he's substantially younger than I am, but he also is senior to me on the court, and he likes to remind me of that on a regular basis. And it's a pleasure to serve with him and our other colleagues on the court. My path started similarly to Judge Torbitsky's. I clerked for a judge in Kansas City, and I got to see what judges do and how they work, and the arguments that move them and that get their attention. And I spent, over the course of my career then, over about the next 25 years or so now, spent a lot of time in courtrooms. And I think there's a tendency when you spend a lot of time in front of judges that at some point you'd like to be the one making the decisions. So my path really to judgeship started with people whose opinions I respected, including a couple of the panel members here today suggesting that that might be something I should look into. So I did and applied. Over the course in the interim, I was, for a long time in the federal system, I was an assistant U.S. attorney for about 15 years. But then I joined the Attorney General's office. I had spent some time in private practice. But at the Attorney General's office, it became apparent to me that a state judgeship was something that I would want to pursue, just given the general jurisdiction of the state courts and the great variety of issues that we get to litigate and on our side of the bench decide were very appealing to me. So that's basically what caused me to apply and to give me the privilege of serving where I do today.
And the judge he referred to was Judge Pasco Bowman on the 8th Circuit. By the way, I talked to him on his birthday in December. He's very much with it mentally, but completely retired from judging. Judge Schelp, path to the bench.
All right, good morning. So my path to the bench was nominated by the president, confirmed by the Senate, but that's not what I want to talk about. So I want to talk about the stress of the confirmation hearing. It's a little bit entertaining. So you sit in a room and you're lined up and all your inquisitors are sitting up there, the senators with their staffers handing them a question. And so when you prep for it, they say, they can ask you anything and whatever. And I'm like, gosh, I'm really terrified of these Democrats. They say, well, wait till tomorrow. We have a special session dedicated to trying to respond to Senator Kennedy's questions from Louisiana. I'm like, oh no, like this could be, super stressful. They said, he likes to ask this one. Let's say, you know what Mardi Gras is? And everyone says, yeah, we know what Mardi Gras is. And he says, it gets crowded down there. And so I want to ask you a question. Let's say they pass a law that says saints, popes, and bishops can't have their progress impeded during Mardi Gras. And then let's say you try to get an autograph from Drew Brees and they arrest you. Is that legal? I'm like, oh my God, if he asks me that question, I'm going to die. So I'm sitting like 1 foot away from him and he's frantically scrolling through his iPad, okay, and he's asking a few questions. There's a countdown. 10 minutes, 5 minutes, 4 minutes. I'm like, oh, please keep talking to the others. And so ultimately he didn't ask me the question. I was confirmed. So that's how I got here.
Hey, that is good. Judge Limbaugh.
Before I talk about myself, I want to talk about my friend Vivek Malik. He's a celebrity. He is your new Missouri State Treasurer. Would you stand up, Vivek? I had the distinct honor of swearing him in to office this last Tuesday in this very House chamber to an overflow crowd. Vivek's a lawyer, a top-end immigration lawyer. He has a beautiful story. Now, you can still get your CLE credits for this. Are you a member of the Federalist Society? Okay. Well, I can't give you a political contribution, but I could give you a gift membership to the Federalist Society, but you already have it. So there. Please get to know our state treasurer, Vivek Malik. Now, as far as I'm concerned, one thing that hasn't been addressed by the judges, timing is a lot to get a judgeship. It's a whole lot. And Judge Benton and I can testify to that. We had a quirk of history. John Ashcroft appointed all 7 judges to the Supreme Court of Missouri. That will never happen again. But Judge Benton, I think, was number 5. Price was 6. I was 7. You talk about timing is everything. It really is on when the vacancies come up and where you are in your own career at that time. And let me just give one other piece of advice. It's not just your academic credentials. It's not just your professional resume. If you want to get on the bench, you need to convince the members of the Appellate Judicial Commission or the governor or whoever is the appointing person that you have used your special skills as a lawyer, first to give back to the legal community and the system of justice, but even more important, use your special skills to give back to the community, to your church, to charities, to communities, and involve yourself in every way that you have time to do, and that will give you a leg up for any kind of judicial office that you seek. Okay.
Are you going to mention piano playing?
What's that?
Are you going to mention piano playing?
Yeah. And the other reason that I got the last appointment, number 7 on the Supreme Court, because John Ashcroft liked the fact that I was a pretty good piano player. Yeah.
And wait, he's better than pretty good. He is really good. And I would just say briefly that have a good mentor, especially if the mentor appoints. The mentors at critical roles. So I would say have a good mentor off the bat. Don't be afraid to be involved a little bit in politics. We have past chairs of political parties in the room. But you hear me, don't be afraid of that. You need a little bit of that for sure. And sometimes you need a lot of it. But that's what I would say, the way I was blessed. But Judge Limbaugh, I hadn't thought about that, but the 8th Circuit seats are up every 27 or 30 years or so. Yes, just you can do the math and think about that. So that's what I would say. So path to the bench. Then the next part of this, we each thought we would prepare something. If you look at our program description, you'll see it's along the lines of the values that are important to the Federalist Society. You'll see that very quickly. And we've split those up. And you notice the focus is on constitutions, state constitutions, is what the focus is. And so we would start with you are past president of the Missouri State Historical Society, right, Steve? I'm sorry if I call you Steve.
Past president.
Yeah, past president. And I'm sorry, we know each other too well. By the way, our wives are best friends. They're even closer. But so pardon me if we get too informal here. But Judge Limbaugh, would you start with an overview of the Missouri Constitution?
Well, let me start with the federal Constitution. We're in year 247 of nationhood. We've had a single Constitution. We've had 27 amendments over that 246 and a half years, 10 of which were ratified in 1791, so only 17 more amendments since that time. Last one was in 1992, an obscure esoteric provision about congressional salaries. Okay. Missouri, in contrast, has had 4 constitutions. The first was in 1820. It was adopted by the Constitutional Convention 14 months before actual statehood in August 10th of 1821. But it was operating at the time we were actually formally admitted. So 1820, then we had another one in 1865 at the end of the Civil War. There had been a constitutional convention during basically the whole course of the war, but they didn't get a constitution adopted until 1865. That was by the radical Republicans. 10 years later, the Democrats flipped the radical Republicans, and we had a new constitution in 1875. That was at the end of, approaching the end of Reconstruction. That Constitution lasted all the way until 1945, and that's the Constitution that we now have operating. There have been some talk about maybe having a new constitutional convention. I don't know much about that. But the interesting thing to me about our constitutional system is that it is the 1820 Constitution, not so much the 1865, but the 1875 Constitution, and now the 1945 Constitution have been amended scores and scores of times. The last Constitution I had was way back when Robin Carnahan was Secretary of State, and I was in the Secretary of State's office, and I got 2 copies of the new one. It's up to date as of 2021, and he even has the pocket parts to it. But I want to go back to the Constitution that was in place when Robin Carnahan was the Secretary of State. And this is 2016, just to illustrate to you. From 2016 to date, there have been 18 constitutional amendments to the Missouri Constitution. How in the world is that happening? Well, there's been an evolution in the Missouri Constitution of 1820. Originally, the amendments were to be passed by 2/3 of each house, the House and Senate. And that situation stayed all the way up through the Constitution of 1865. And at that point, the Constitution was changed again so that by a majority vote of the legislature, the people would then vote on whether to adopt the amendments. So that's the first time the people actually got involved. Then in 1908, I think, that's the first time we had an initiative. That was by way of an amendment to the 1875 Constitution. And now, of course, we have either the initiative petition process, which is the root of most of these 18 new amendments over the last few years, and also, of course, the express provision that allows the legislature to put something on the ballot, a constitutional amendment, just by a majority vote of each house, the House and the Senate. So I'm setting this up for one of our other speakers who's going to talk about some of the problems about all of these bills coming into play, all of these constitutional amendments, coming into play by nothing but a majority vote of the people. But let me go back and talk briefly about the judges. So in the Constitution of 1820, there were set up for just have 3 judges on the Supreme Court and then 4 circuit judges. The state was divided into 4 circuits. The Supreme Court judges would go to each of the 4 circuits for 2 terms of court per year, and then there would be a circuit judge. Now, the qualifications had to be 30 years old, and the mandatory retirement was 65. That's pretty similar. But the selection of the judges was based on the federal Constitution. So when we became a state, the new governor, Alexander McNair, appointed the judges, both the circuit judges and the Supreme Court judges, to their offices, and for life terms, or at least till age 65, just like happens in the federal level, with the advice and consent of the Senate. There was no provision for a Chief Justice, but I've come across some interesting research. You will find in Volume 1 of the Missouri Reports the first set of rules of court adopted by the new Supreme Court, the 3 judges. And one of those, rule number 1, says there shall be a president of the Supreme Court. So I asked our Chief Justice, Paul Wilson, would you prefer president or Chief Justice? And I took him aback, but he said president. Well, that was on the books. That rule was on the books till about 1890 or so, even though all along people generally referred to the president as really the Chief Justice. Now, there was another little tidbit that I share with you in that first Constitution. It was written by, the judicial article, Article 5, was written by lawyers who were members of the 41-person Constitutional Convention in 1820. And those lawyers were shrewd because they knew they might get some spoils from their service on the Constitutional Convention. Sure enough, the first 3 judges appointed to the Supreme Court were all members of the Constitutional Convention. Now, they snuck this little provision in the first Constitution that says they shall serve on terms of good behavior, but the compensation of judges shall be at least $2,000 and shall not be lowered. Well, so the Constitution goes into effect. The new legislature comes into power, the newly elected legislators, and that $2,000 per year provision caused a great outrage. That was a handsome sum at the time. A handsome sum. So the new legislators, the second or third amendment to the Missouri Constitution was to cut out that $2,000 for the Supreme Court judges and the circuit judges. And they reduced the salary from $2,000 to $1,400. So anyway, going back to the evolution of our judicial system and the courts, it was in 1851 that the populace decided that they were fed up with gubernatorial appointments of judges. It is kind of leftover populism, Jacksonian democracy kind of thing. We're going to elect our judges now. And so a constitutional amendment was enacted, and popular selection of judges from 1851 to, all of you know, 1940. 1940 was the next constitutional amendment, amending the Constitution of 1875, before the new Constitution of 1945. And so we have the Missouri Nonpartisan Court Plan that you're all familiar with, that came about because of all the corruption in the popular election of judges, mainly due to the scandals in the Pendergast machine. So now we have the Appellate Judicial Commission and Nonpartisan Court Plan and gubernatorial appointments from a panel of 3 selected. That plan has come under a lot of fire. From time to time, tweaks have been offered. They've all been defeated. Even the Federalist Society, 15 years ago, made a pitch to throw out the Missouri Nonpartisan Court Plan, and it was defeated too. But the idea was that we should go back to popular elections. I think I'll just be frank with you. Their concern then was that there were too many, how shall I say it, tactfully, there were too many plaintiffs' lawyers types that were getting appointments or liberals who were getting appointments to the Supreme Court. And they felt that Missouri was such a red state, well, let's go back to electing our judges by popular election. So that was defeated. They were really concerned too about the makeup of the Appellate Judicial Commission, because the lawyer members were generally plaintiffs' lawyers, and my response to that is that we ought to keep the Nonpartisan Court Plan because it takes the money out. The money is the most corrupting thing in the selection of judges. Look at Illinois, Alabama, Texas, and elsewhere. Plus, we have a screening mechanism here with the Appellate Judicial Commission. And my other response to my Republican friends is that, well, the problem is you elect Democrat governors. What do you expect? If you want Republican-oriented judges, Federalist Society type folks, elect Republican judges. Don't blame the system on that. And actually, the system can be tweaked just as it was when Judge Benton and I got on. John Ashcroft ran the table by using the Appellate Judicial Commission, and, well, he got Chip Robertson on as Chief Justice, 3 lay people over the course of 7 years, and he could run the table. So the Republicans did it just like the Democrats did when the Federalist Society was criticizing them. So anyway, that's maybe too much information, but anyway.
No, this group likes information.
Okay,
And
I'll just skip to the next person. How about?
yeah, sure. And I was going to say, I thought, and we have a theme here, you all should know that Judge Stephen N. Limbaugh Sr. is doing great. Doing great in every regard. Many of you know him. And he has several, how many of you heard him speak about Missouri history? He's spoken to Missouri State Historical Society 2 or 3 times, and to the Supreme Court Historical Society 2 or 3 times. So that's our theme so far. We turn now to Judge Schelp. If you would address role of the trial judge versus appellate judge.
Okay, so when given this assignment, I laugh because I'm, kind of difficult for me to believe that I could say anything that was worthwhile to anyone in this room about the differences between the role of a trial judge and appellate court judge. I'm sure everyone's quite aware of that. I do have a couple comments, though, maybe the only place I can go with this is just sort of philosophically sort of how I view my role as a trial judge, and how that intersects with the process of the appellate court. And I'll try to use a case that I have, but I'll start off by saying that what I found as 20, 25 years as a litigator, one of my greatest frustrations was being before trial court and, not having a decision being made, having a delay in the decision being made. And I think many of you probably would agree in many instances, that frustration is and sometimes even more significant than not getting the decision that you want. I mean, because, I think that really the primary role of a trial judge is to resolve disputes between parties. And to do that, you have to make decisions. And of course, trial courts can't do that, or can only do it to the best of their ability with the help of effective advocates, on both sides. But ultimately, it's up to us to decide the mix of law and facts and make a decision. And so for me, in thinking about what the intersection between the appellate courts, like, of course, I don't want to get overturned, and I would say that anytime that the appellate court reverses something that I do or something that a trial court judge, I sincerely view it as a failure of the justice system, in a sense that it delays the resolution of that dispute, which again I view as my primary role. And certainly, I think we can all agree that there's appropriate place for certain things to be reversed, certain things to be overturned, and that's a necessity. But as a trial judge, I certainly want to avoid that. I think probably the easiest way to sort of describe how I've evolved. Now, keep in mind, I've only been a district judge for 2 years. Okay, so check with me in 10 years. But 8 months into my tenure. And I can't talk about the specifics of this, but I can talk about the public portion of this because this is still an ongoing case. 8 months into my tenure, the computer, ding, you got an email, you've been assigned a new case. And I was assigned the case where a coalition of plaintiffs, including the Missouri Attorney General, were challenging the Biden administration's vaccine mandate. So I'm 8 months into the job, 9 months into the job, and I look down and like, okay, wow, this is a big one. And so it's kind of a little daunting, and you can, I think that it's easy if you have to be comfortable making decisions, you have to be willing to make a decision. But as the decisions get bigger, sometimes it becomes more difficult. You have a little bit more of a fear factor. You have a little bit more of a hesitation to move forward. And so when I talked with my law clerks, when I talked with my staff, we said, we're going to do the same thing we do in every case. We're going to do the best we can. We're going to follow the precedent. We're going to try to, resolve this as we think justice demands. And so we went about and we issued an injunction. Now, as a side note, one of the things I get in trouble for at home with my wife is she often accuses me, believe it or not, of not talking enough about work, okay? And I said, well, that's, I don't know that a lot of people have that complaint, but, she says, you never really say what's going on. So I texted her as we were working through this opinion we were writing about the vaccine mandate. I said, hey, honey, we're going to issue an opinion later today, and just as an FYI, that may get a little bit of buzz, okay? So I was honored to be the first court to issue an opinion as to the legality of the vaccine mandate. Ultimately, the Supreme Court disagreed with me. Again, the case is ongoing. But I issued the opinion, and she texted me back a picture from the Daily Mail with my face next to Joe Biden's. She says, is this what you mean? I said, yeah, see, that's how it is every day in the Eastern District of Missouri. But ultimately, it can be very intimidating, but this is where my brethren from the appellate courts come in. The thing about the beauty of our system, and what you do have to remember as a trial court judge, is this. You're not the final answer to something. Parties have the opportunity to appeal your decisions. And frankly, I always say to my staff, let's not let perfection get in the way of progress. And sometimes there's more progress made in making a decision than there is in trying to make the perfect decision. And so ultimately, I think most of you may be aware, just from kind of the general nature of it, the Supreme Court sort of held an unprecedented procedural hearing it went over 3 hours, and I listened to it, and addressing both the decision I made, a decision that a district court judge in Louisiana made, as well as an unrelated decision related to a similar mandate that was that related to OSHA. And so anyway, I think that, the other thing I'll say, just from a trial court practice, and, again, I doubt you all need any of my tips, but what I would say this, I think that someone said common sense, know your judge. I really do believe in the, driving toward resolution of these disputes. And I have a very informal process in that regard. For example, when I'm doing a trial right now, we're not having a trial day today, but as we moved forward that trial, I had a multitude of status conferences and different hearings with the parties to try to iron out the issues for the trial. And what I'll say is oftentimes I run into a tension where I can tell that a lawyer is really trying hard to preserve an appellate issue more so than maybe driving toward the resolution of that case. And I think that I like to be frank about that, and try to, again, get to that point where either I or the jury decides the facts and resolves that dispute, because I think ultimately that's our job. And philosophically, again, if we don't do that, then we've failed. So that's my comment.
Thank you, Judge. Next, we have Judge Torbitsky, State Constitutions Protecting Individual Liberty.
Thank you, Judge Benton. This just may be my own insecurities at play here, but I couldn't help but notice that all of the federal judges were in the middle and the two state judges had been relegated to the corners of the room.
By seniority of tenure. Go ahead.
Okay. All right.
Primacy clause.
You find that offensive, Judge Trubisky?
No, I wasn't going to read into
previous
it.
discussion.
I wasn't going to. I just assumed it was an honest mistake of some variety. Nevertheless. So in preparing these remarks, and you'll forgive me for more or less reading them to you, I reread a law review article by Justice William Brennan, who published in the Harvard Law Review in 1977 called State Constitutions and the Protection of Individual Rights. I think there's a copy of it in your materials. And for those of you who've not yet found the time to read a law review article published by William Brennan in 1977, I'll give you a little bit of a recap. In the article, Justice Brennan posits that the Supreme Court of the 1970s had begun to pull back from the application of a principle set forth in Boyd v. United States that courts should broadly construe constitutional provisions that guarantee security of person and property. Brennan said that it's the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachments thereon. But Justice Brennan believed that at the end of the Warren Court in the 1960s, the Supreme Court had kind of stepped away from this obligation and seemed less than willing to find violations of the Federal Bill of Rights and the 14th Amendment. Nevertheless, he saw some hope for the protection of individual liberties through a series of decisions in state Supreme Courts in which states interpreted their constitutions to afford rights broader than those provided by the United States Constitution. Brennan, he applauded these state courts. He pointed out that decisions of the United States Supreme Court regarding the federal Constitution are not dispositive of questions regarding rights guaranteed by state constitutions. He therefore encouraged state court judges and practitioners to scrutinize constitutional questions and not just mechanically apply United States Supreme Court decisions to state constitutional issues. He thought that this was good not just for the protection of individual liberties, but for the concept of federalism. As we all know here, states are separate legal entities from the federal government. They need not operate in lockstep with the federal government. Instead, they can provide additional rights, even those not guaranteed by the United States Constitution. So we find ourselves here 45 years later and still exploring the role that state constitutions can have in protecting individual rights. It probably won't surprise any of you to know that there are a lot of law review articles on this topic. I mean, Justice Brennan's article has been cited by over 1,600 law review articles. And I'll spare you a recap of any of those because probably recapping one law review article is enough for any given presentation. But I say that just to point out that this topic is it's a popular one, and it's also a really important one. You know, state constitutions are frequently used to ensure and protect individual rights. If we generalize, it's typically done in one of two ways. The first is when a state constitution expressly grants rights to the citizens of the state that are not granted by the United States Constitution. Missouri's Constitution, I'm sure most of you know, contains a right to farm, which is not found in the United States Constitution. It also, as we all know, now contains the right to recreational use of marijuana. Not surprisingly, these additional rights, particularly the more broadly written ones, lead to more litigation, and that can lead to further expansion of these rights. I'll give you an example. So the Missouri Constitution at Article 1, Section 29 provides that employees shall have the right to organize and to bargain collectively through representatives of their own choosing. But in the late 2000s, a teachers' union reached an impasse in its negotiations with the school board regarding teacher salaries. The union believed that the school board was not negotiating in good faith. Because the National Labor Relations Act does not cover state employees, the union sued the school board in state court, arguing that the failure to negotiate in good faith violated the Missouri Constitution. The union argued that although the Constitution doesn't expressly guarantee an obligation on an employer to negotiate in good faith, the right to collective bargaining is effectively worthless without it. In a decision called American Federation of Teachers v. Ledbetter, the Supreme Court of Missouri agreed. The court held that the right to collective bargaining contained in the Missouri Constitution necessarily imposes an obligation on the employer to bargain in good faith, despite the fact that that particular right is not enunciated in the Missouri Constitution. So the same type of argument was kind of front and center in a recent decision in the South Carolina Supreme Court that some of you are probably familiar with, Planned Parenthood South Atlantic v. South Carolina, in which the court held that the Carolina Constitution protected a woman's right to terminate a pregnancy. So there's another panel later that's going to talk about abortion issues, so I'm not going to delve too deeply into this case other than to say that much of the rationale for that decision was based on a provision in the South Carolina Constitution that guarantees South Carolinians, protects South Carolinians from unreasonable invasions of privacy, a clause which, of course, is not included in the United States Constitution. So the other way that constitutions can serve an important role in protecting individual rights is the one discussed by Justice Brennan. That's where a state court will more broadly interpret a similar right that's also found in the United States Constitution. So for these type of cases, a litigant will typically need to provide the state court a really good reason to depart from the United States Supreme Court determination or the way that they've interpreted it. Missouri, for instance, has repeatedly held that though the provisions of the Missouri Constitution can be interpreted more broadly than the way that the United States Supreme Court does, that any interpretations by the U.S. Supreme Court are strongly persuasive in construing the like section of the state constitution. In other words, you need to provide a good reason for a different interpretation. I think one question to consider is how a state court interprets its constitution. So does the state court apply a purely textualist approach where they only care about what the words on the page are and they don't care about anything else? Do they apply a more originalist philosophy? Or are they, and if they do that, are they going to adopt the more, the originalist philosophy that was demonstrated by the United States Supreme Court this past term in decisions like Dobbs and Brune? At the risk of, again, kind of stepping on the toes of the afternoon panel, the Kansas Supreme Court decision in Hodes and Nausser v. Schmidt, which again upheld the right to terminate a pregnancy, provides a good example of a state court giving a more expansive interpretation to a similar provision of the Constitution. So the Kansas Constitution contains in Article 1 a statement that all people are possessed of equal and inalienable natural rights among which are life, liberty, and the pursuit of happiness. Numerous opinions of the Kansas Supreme Court had likened this provision to the guarantees of life, liberty, and property contained in the 14th Amendment. And they'd interpreted it routinely in the same way. But in Schmidt, the Kansas Supreme Court changed course and held that nothing required it to interpret the Constitution in the same manner as the federal Constitution. As a result, the court found that one of the natural and inalienable rights that are protected in the Kansas Constitution was the right to personal autonomy, which included the right to control one's own body. So in closing, I'm just going to sum up the point of these remarks as pointing out simply, as Justice Brennan did 45 years ago, that the U.S. Supreme Court is not necessarily the final word for the protection of individual liberties. Though the state constitution may of course afford no narrower rights than those provided by the U.S. Constitution, it can always provide additional protections. In advocating for or even against a particular right on behalf of your client, you'd be really wise not to neglect your state constitution, because you can find a lot there that may not be in the U.S. Constitution.
Thank you, Judge. And then to the other end, Judge Stevens is going to talk about, and Judge Limbaugh set up the historical background, but he's going to talk about some present indications of the ease of amending the Missouri Constitution. Your Honor.
Thank you, Judge. Yeah, Judge Limbaugh teed this up perfectly. I appreciate that. What I'd like to talk about in a little more detail today is the tendency in recent decades of proponents of consequential policies pursuing those policies through amending the Missouri Constitution by initiative petition. We've seen that, as Judge Limbaugh pointed out, over and over and over again in recent decades, particularly the last 40 years. So basically what they're doing is they're going to initiative petition. It's a direct vote of the voters of the state of Missouri to decide these issues. There's an inherent tension there within the Missouri Constitution with the Republican form of government that we have. By that I mean the representative form of government. Of course, we are sitting in the House chamber today. We vote for representatives, the Senate and House members, who are paid to decide and vote on consequential issues. Yet we've seen a lot of those decided by constitutional amendment by popular vote. And so there's a somewhat of a tension there between sort of those two forms of government that are enshrined in the Missouri Constitution. And so that leads us to, I think, predictably, the Missouri General Assembly's, the leaders of the General Assembly's recent expressions that they intend to make a priority this session, making it more difficult to amend the Missouri Constitution. And I'll talk a little bit about the reasons for that, how they would go about that, and the arguments in favor and against that have been expressed by those who would like to see that done and those who have used the initiative petition process to their advantage and would rather not see that happen. So that's what I'll talk about today. First, as mentioned, there have been numerous examples of these initiative petitions in recent years. As was mentioned previously as well, the most recent, of course, is just last November. A narrow majority of Missouri voters approved a initiative petition to amend the Missouri Constitution to make legal the recreational use and possession of marijuana, as well as expunging prior marijuana convictions. That was just this last fall. There are many other examples. Going back to 1980, a notable one, of course, is the Hancock Amendment, which made it more difficult for the General Assembly to raise taxes. Shortly after that, in 1990, there was a proposed Amendment 5, ethics reforms to reduce the number of members of the General Assembly, create an ethics commission, change the length of the session of the General Assembly, those sorts of things. Very broad, basic changes to the Missouri Constitution. In 2020, of course, we had Medicaid expansion, and then just last fall, the marijuana initiative. So there are many examples of this over recent years. It's become a very popular way for people concerned about particular issues to get those enshrined into Missouri law and into the Missouri Constitution. Now, these initiative petitions are made possible by the Missouri Constitution, as Judge Limbaugh referred, that the ability of the people to amend their constitution by initiative petition has existed for over 100 years, since 1908. It was what was seen then as a progressive reform to state government to allow citizens of the state to do that. Previously, that power had been held by the General Assembly, where they would submit a petition to the people and they would vote on it. And only the General Assembly could initiate those petitions. That changed in the early 20th century and exists to this day. Specifically, Missouri Constitution Article 3, Section 49 reserves the power of the people to amend the Constitution by initiative petition. So this comes out of Article 3 of the Missouri Constitution. Interestingly, and I'll talk about this a little bit more as we go on, it also reserves the power of the people to approve or reject an act of the state legislature, of the General Assembly. Very similar processes that are set out in Section 49. The major difference being that one is the initiative petition is constitutional amendment. The referendum process deals with acts of the legislature, statutory law. Section 50 of the Article 3 of the Constitution goes on to provide that initiative petitions must be signed by 8% of the legal voters in each of 2/3 of the congressional districts around the state. So that's the requirement for proponents of these petitions to get those petitions on the ballot. Similarly, the threshold for the referendum situation, the referendum process to change acts of the General Assembly, or to basically to institute statutory law, is 5% of those same voters. Fairly similar, but slightly lower threshold. And then Missouri Constitution, Article 3, Section 51, as well as Article 12, Section 2B, set the standard for what is required with the vote of the people. That is a simple majority for either the initiative petition to amend the Constitution or the referendum to change statutory law. Simple majority is all is required, just over 50%. The Supreme Court of Missouri has, in case law, lauded this initiative petition process as, quote, participatory democracy in its pure form, which I think is interesting because, as I mentioned, there's an obvious tension in the Missouri Constitution between this participatory democracy in its pure form and our representative form of government is sitting in the chamber of the House of Representatives. The same Article 3 of the Missouri Constitution that provides for election of our senators and members of the House also provides for this initiative petition process. And by definition, our Constitution setting forth this Republican representative form of government, by definition, a Republican form of government is not a direct democracy. We don't all, as citizens of the state of Missouri or as legal voters, as is required under the Constitution and initiative petitions, we don't show up here in this chamber and vote personally for these laws. We elect representatives to consider these consequential issues and to vote on our behalf in this chamber and in the one across the hall. So there are really two different systems at work in the Missouri Constitution. Of course, representative democracy, representative government, Republican form of government is not a direct democracy. It also is not a monarchy. We don't have a king. So that's basically what we have set up in our Missouri Constitution. The reason I mention that tension and sort of the dichotomy there is because this is a Federalist Society meeting, and given the nature of this topic and the tension we see in the Missouri Constitution between these two forms of government, I thought it'd be interesting sort of to talk a little bit about what Publius would think of this in the Federalist Papers. And it's quite obvious. In number 10, Federalist number 10, James Madison makes pretty clear what the history of direct democracy looks like and what the cure for the factions created by direct democracy is. In Federalist 10, he more eloquently than I can points out that in direct democracies, measures are too often decided not according to the rules of justice and the rights of the minor party, but by the superior force of an interested and overbearing majority. He goes on to talk about historically his observation that hence it is that such democracies have ever been spectacles of turbulence and contention, have ever been found incompatible with personal security or the rights of property, and have in general been as short in their lives as they have been violent in their deaths. And of course, in number 10 and other the Federalist Papers, Madison goes on to prescribe as a cure for those maladies of direct democracy a Republican form of government. That is a form of government where you have representatives elected by a large number of citizens across, ideally, a large geographic area. And so I think he makes it quite clear what his views are after an historical view of direct democracies and of Republican forms of government. So now, all of that said, let's get down to a little more practical implications here of what we have going on in our state government in recent decades. I think, as I mentioned at the outset, it's not necessarily surprising to any observer that the General Assembly has in recent years, and particularly at the very outset of this session, the leaders of both the House and the Senate have expressed that they would like to see changes to the initiative petition process. They've talked about making it more difficult to amend the Constitution through that process by first possibly increasing the number of signatures needed in order to get those petitions on the ballot in the first place, and secondly, to increase beyond just a bare majority the number of votes needed once the petition is on the ballot to approve that petition. They argue in favor of making those changes that, as Judge Limbaugh observed, that Missouri in recent decades has voted overwhelmingly for Republican and conservative state legislatures, veto-proof majorities in both houses. The proponents of these reforms point that out, and that the initiative petition process in recent years has basically become an end run around those majorities. They point out that the Constitution is meant to be a basic framework, and in great contrast to the United States Constitution, as Judge Limbaugh pointed out at the beginning of his remarks, the Missouri Constitution has been inundated with pages and pages and pages regarding things like bingo, riverboat gambling, the lottery, horse racing, and now the recreational use of marijuana. Hardly things that are really deal with the fundamental structure of our state government. They argue that the initiative petitions lead to bad policies simply because they're often sponsored by special interests, often from out of state, that spend a lot of money to get those passed, and there often isn't organized opposition to those petitions or money to argue the other side, so that the citizens of the state of Missouri and the legal voters who decide these issues often aren't getting the full story. Similarly, there are limits to the description that can be included on the ballot of exactly what these petitions are. Sometimes there are dozens and dozens of pages of changes to the Missouri Constitution, but you have a very short description necessarily on the ballot. And if people, you'd like to see voters obviously look for sources of information regarding these on their own and educate themselves. But to the extent they would expect the description on the ballot to fully inform them of what they're voting for, that's just practically not possible. So those are the arguments that are made. One additional argument is that relative to the referendum process, where you can change an act of the state legislature, approve it or reject it or what have you, it's simply too easy to amend the Constitution. And 8%, the signatures of 8% of the legal voters in 2/3 of the congressional district versus 5% simply doesn't make that much difference. And it ought to be harder relative to changing statutory law to amend the Constitution. So those are the arguments that proponents of these changes make. Now, there are individuals and entities that have used this process quite often, and others who simply are in favor of being able to amend the Missouri Constitution as easily as it currently is. And their counter arguments are generally that it's been enshrined in the Constitution for more than 100 years. It's worked, and so why mess with that? some would argue that maybe it hasn't worked quite as well as it should, or that it's meant bad consequences for our Constitution. But that's the argument they make. They also argue that and I think accurately, that the initiative petition process has been used by groups and individuals of all different persuasions. You have everything from fiscal conservatives in 1980 with the Hancock Amendment to proponents of Obamacare 2-3 years ago with the expansion of Medicaid. And so I think that their argument in that respect is accurate. They also point out that they argue that rather than making it more difficult to amend the Constitution, maybe the legislature should make the referendum process more attractive. That is, I think one reason you see groups going directly to the initiative process to amend the Constitution is simply it's not that much harder than changing statutory law under the referendum, and it's essentially a permanent enshrinement of that policy in the Constitution. So the people who are in favor of that say, well, let's not make it harder to amend the Constitution. Let's make the referendum process to make statutory changes more attractive by having, for example, a cooling off period where the General Assembly couldn't immediately change what policy has been put in place by a recent referendum, or change the threshold that would be necessary for the General Assembly to reverse a change that's been made in the referendum. So those are the arguments that were made. Now, interestingly enough, and I'll wrap up here in just a minute. Interestingly enough, this may be essentially moot. As much as the leaders of the General Assembly have made it clear that this is a priority, really there are very few options for how they change this. Essentially, it is that the General Assembly would basically go through a very similar process to amend the Constitution to do this that is done through the initiative petition. So what they would have to do is, by a majority of each house of the General Assembly, they'd have to vote to make these changes, which would get them on the ballot. But then you'd be asking legal voters in the state of Missouri to decide to make it harder for themselves to change their Constitution, which it seems to me could be an uphill battle, but I guess time will
Judge
tell.
Limbaugh, I read your body language.
Yeah, I just want to add one other aspect to what you were saying, because we have two former senators, Kurt Schaefer and Steve Ellman, in the House, and I have at least the perception that sometimes it's the legislators themselves who are trying to get these on a ballot, either constitutional amendments or otherwise, in order to not have to make tough decisions. I'd sure like to hear from you whether that's happened before. I'm sure it has. We have so many amendments. Surely some of them have originated because of that concern. I don't know.
Well, thank you,
Hey,
Judge.
go ahead, sure. And
me out there.
we're open for questions, two mics in the back. But start with that, please.
Judge, if you don't mind, can I address? I'll address that now since I was kindly called out.
Yeah, sure.
Yeah, I mean, when I was Amendment 5, which in 2014 was passed by almost 70% of the Missouri voters, was mine. It added language to the Missouri Constitution that protects our right to keep and carry arms, and it added ammunition and some other things like that, that to your point are not things that are specifically in the United States Constitution, but are now specifically enumerated in the Missouri Constitution. So that would be a good example, Judge, of what you pointed out of maybe state constitution going a little bit farther. You know, I think the issue is, and I think there's probably this session, which just started 3 weeks ago, there's probably at least 40 House and Senate resolutions dealing with this issue. So they're going to get to it. And I think that leadership has made it clear it's a priority. But you've got to break it down into kind of two questions. And one is, how hard or easy is it to get an initiative petition far enough through the process to get it on the ballot? And then how hard is it to get it passed once it's on the ballot? And I think that there's a message there to say maybe it should be easy, or like it is now, to get it on the ballot, but it should probably be more difficult, particularly in a constitutional amendment, to change the Constitution. I think referendums probably should be easier. But to Judge Limbaugh's point, you know, I think there are times, and especially post-Dobbs, I think we're going to see what happens. I mean, I think that sometimes there is a willingness to punt an issue and just put it out there and say, you know, we've been dealing with an issue for 20, 30 years. We can't get it done. Let's just send it out to the voters. But sometimes that's the right decision to make if it's a hard decision that needs to be dealt with. I think it goes both ways. I think sometimes it's a useful process for the legislature to get some things done, and I think sometimes it's abused. And I will tell you, for those of us that have been in the political realm, most political consultants will tell you if you can raise $3 million, and it doesn't matter where it comes from, it can come entirely from out of state. If you can raise $3 million, you can get on the ballot, you can probably get it passed. And that is true, especially if you don't have any opposition, for example, with marijuana. So the process needs to be there, but it probably needs some fine-tuning.
Steve Aylman, I see you at the microphone. Go ahead.
Yeah, thanks, Judge. I would suggest sometimes it works the opposite direction. And when the legislators refuse to put something on, then the people do, either a referendum or constitutional change. And Judge Limbaugh, you mentioned there was an ethics effort back in, what was it, 88 or 89?
1990.
91.
1990, and it was put together by people who didn't understand much about what goes on here, but were very frustrated because the people here wouldn't do anything about ethics. What happened is, with that as the alternative, the legislature did get serious, and the very next year we did pass an ethics bill, which was quite significant. And in many ways, it was even more strict than what they did, but it was something that would work because it was written by people who understood how things work here, instead of some outsiders who realized the problems here, but really didn't understand the way to fix them.
Thank you. We'll go back to next in line at
Judge
the main mic.
if I could, real quick.
Oh, yeah, go ahead.
I
Sure,
just,
please.
Having heard from the senators, I had noticed something from the Missouri Supreme Court I thought was interesting, and I think it highlights, obviously we're a panel of judges, a very different job than the legislators that sit in this chamber and the former senators that we've heard from. And the Missouri Supreme Court says this, I think, leaving everyone with these cautionary words about the initiative petition process and judges' roles in reviewing these things. Missouri Supreme Court said in Buchanan versus Kirkpatrick back in 1981 that inherent in the power of the people to alter or amend or abolish their constitution is the power and right to amend wisely or unwisely. Questions of policy are not questions for the court. They are wrought and fought out in the legislature and before the people. When a constitutional amendment has been submitted, the single inquiry for us is whether it has received the sanction of popular approval in the manner prescribed by law. So I'll leave you with that.
Good. Next in line. Go.
Thank you, Your Honor. My name is Dave Rowland. I'm the Director of Litigation for the Freedom Center of Missouri, and I've spent the entirety of my 18-year legal career fighting to advance individual liberties. In part, that has included drafting constitutional amendments like Amendment 5. I drafted most of the language that Mr. Schaefer advanced in the legislature, and it leads perfectly into this conversation we're having today because in 2015, the Missouri Supreme Court held that that language worked no substantive change in Missouri law. We drafted that language specifically to give this state the strongest constitutional protections for the right to keep and bear arms in the entire country. And 5 members of the Missouri Supreme Court gutted it. That prompted me to start applying for vacancies on the Missouri Court of Appeals when they came up, in part because I had never heard a judge like Turbitsky articulate a vivid understanding of the importance of individual liberty and the role of the state constitution in protecting that individual liberty. Over the last several years, I've encouraged a number of people, including several people in this room, to also throw their hats in for these vacancies that appear on the courts, because if we are truly going to advance individual liberty, we need judges on the bench who understand these issues at a very fundamental level. Thus far, I have been unsuccessful in persuading others to try for this. And so my question for the judges is, would you please give your best selling points for why the people in this room should make that effort, should take that initiative to apply for judicial vacancies in Missouri, 2 of which will be coming up on the Missouri Supreme Court later this year. And by the way, Governor Parson is, I believe, in the process of appointing his 3rd lay member of the Judicial Appellate Commission, setting the stage for a similar situation to what Judge Benton mentioned earlier. So if you would, please, your best selling points to get these people
Judge Turbitsky, mostly
running for these
yours.
offices.
Go ahead.
You don't have to do discovery anymore.
Okay, good question, good answer. Okay, down here.
Well, it's a great way to serve the state, and frankly, personally, they're fascinating issues we deal with every day, and these included. So, my pitch would just be that it's a great way to serve. As lawyers, we have a unique opportunity here to serve not just as advocates for our clients, but as judges for the state, and it's hard to find a better way to serve, in my opinion.
Okay, next question. Go ahead.
Thank you, Judge Benton. My name's, most of you know me, John Reeves of Reeves Law, LLC. I'm a solo appellate practitioner in St. Louis. I think this discussion, particularly Judge Christensen, your discussion of the Federalist Papers, the threats of pure democracy, the way the ease with which our Missouri Constitution can be amended and the referendum shows the dangers of that. My question is, and this may be beyond the knowledge of anyone here, but I think it's a good one for purposes of contrast. To the best of any of your knowledge, is there any other state in this country whose constitution is even remotely able to be amended as easily as our Constitution is, or Judge Benton, go ahead.
No, I thought you were finished.
Or has a similar referendum process? Like, how are we in comparison to other states?
Let's see. Did anyone do specific research? We discussed it briefly on our call, but no one did specific. Did you do specific research on it?
No, but I did come across it. There are other states that have very, very similar.
Yeah.
I think this was a national, regional and national movement in the early 20th
come on.
century.
I'm going to make you do it. Come on.
And so there are other states that have that similar processes. Several of those states actually in recent years have attempted to make it more difficult to do these initiatives, and they failed.
Okay.
But there are other states that just have a 51%
We have a
passage
couple
rate.
people up here closely. Eddie Grime, is there 26 states? There's a magic 26 number and some other numbers. Come to a microphone and tell us. Come on. Come to a microphone. Come on. Because it's recorded and everything. You see over here. No, just come quickly to the microphone and give the quick numbers that we know.
Okay, well, I don't know the numbers of people who have kept our system, but we borrowed ours from Oregon. And so it was the western states that were the strongest and some of the midwestern states. And so even today, the ones most like ours are Oregon and Washington State. Oklahoma is very strong too. And California is where all the petition companies go make their money. They have a very strong...
Hey, I've heard the number 26, that there are 26 states that have active initiative and referendum to bring this point. There are 10 or 12 northeastern states where you can hardly amend the Constitution, period. I can tell you a lot about it, but that's a short summary.
Just like by contrast, just like I know in Pennsylvania, to amend the Constitution by contrast, I was stunned when I read this. To amend the Constitution in Pennsylvania, it has to be passed both houses of the Pennsylvania legislature by, it's either 2/3 or 3/4 year one. Then it has to be passed by the same again the following year. And only after that happens, then it goes to the people for a statewide referendum at the next election. So literally, it's like a multi-year process.
Some states have yet another council of revision or some such. How many states have that in the Northeast? Where even after all that vote happens, it goes to some council made up of elected officials.
Well, I thought the main push is just to get the threshold from 51% up to something like 60. Isn't that right?
Okay.
Isn't that the proposal?
I'm not sure. It just Anyway, thank you. It illustrates the contrast when we know how other states are.
At the outset of your question there too, you mentioned again the issues with direct democracy. I point out that the Missouri Constitution is interesting in that respect as well, because what Madison observed was that what happened to direct democracies over time was that a majority realized they could vote themselves the treasury, or they could vote themselves everyone else's property. And so the Missouri Constitution, Article 3, Section 51, actually specifically prohibits the use of initiative petition to appropriate money, other than money that's raised by that actual petition.
Which raises very interesting questions in the Missouri Supreme Court. And several in this room are intimately familiar. Professor, go ahead, Professor.
My name is Colonel Bill Eckhart. I'm a law professor at UMKC, retired. And I rise as a principal spokesman for the reform process of the Missouri Court Plan some years ago to assure that the Federalist Society in no way intended to become political. We refused at all stages to discuss the validity of any particular decision. We were sparked to do this with reliable press reports that the Missouri system itself was beginning to break down, with judges being vetted by certain firms in town during the selection process, which indicated to us that we needed to take at least a look at this particular system. I would never have participated if the goal had been the election of judges, but we certainly discussed all sorts of different ways that the system could be reformed. My observation of what happened is exactly what happens often in our legal profession. The revered Missouri Plan righted itself in several very important ways. And some of us who were bruised by that contest took some pride in the fact that the plan that this state genuinely believes and correctly believes has such a revered court plan was put back on the tracks. I would just say to all your judges as I leave that that's an old plan. It's an old plan, and from the 40s, and reform is often necessary. And I would encourage us, you especially, because we citizens rely on the integrity of our judiciary, and we take such pride in this plan, to be very careful and help change that when it becomes necessary, and ensure that the train runs on the track. Thank you for being
And
privileged
Professor,
to rise.
you have the article with John Hilton 15 years ago. Is it UMKC's Law Review? About the plan, and it like what Judge Torbitsky did, summarizes the various aspects. John's father is Steve Hilton. Many of you knew Steve Hilton, Press Secretary to Senator Danforth, Press Secretary to Senator Ashcroft, and several other positions over the course of his career. So I would commend to you the professor's article with John Hilton.
Now, one improvement that has been made recently is to help with the transparency of the process, so that the interviews are open now to the public, and so that was a big help, I think, don't you, Professor?
There were several things that happened. More vibrant elections for certain positions. The chief judges on at least 2 occasions reporting to the legislature and doing things. So they're very good. But it's important that there are all sorts of ways that one can manage appropriately within the spirit of this plan. And I just encourage you not to overly praise the plan and ignore modernization necessity. That would be my plea. Thank you.
Justice Sandra Day O'Connor, many of you know, came to the University of Missouri Law School. By the way, she's a strong proponent of the basic Missouri plan. But she was vehement. There should be twice as many lay people as attorneys to balance out the influence. Well, and she said that clearly. Go ahead.
And then another proposal that's been floated around a lot is to perhaps add to the 7-member Appellate Judicial Commission maybe a representative from the House and a representative from the Senate. It gets a little unwieldy then with 9 instead of 7, but that's been floated around too. Go ahead.
Question? Perhaps our last one. We'll see how long it takes. Go ahead.
Thank you, Your Honor. I'm a student at Washington University School of Law, and so my question has a little bit more to do with how you instruct your law clerks. You mentioned, Judge Schelp, that you want decisions to come out promptly, and that's kind of one of the fundamental reasons that trial judges make decisions in the pace that they do. But originalism takes time, it takes resources, it takes effort. How do you instruct your clerks to balance between getting decisions made quickly and doing the thorough, important research on novel questions like President Biden's vaccine mandate?
Start with you, Judge Schelp.
Well, first of all, from a resource standpoint, I mean, the federal judiciary is pretty. We're embarrassed with riches. I mean, I have 3 very talented lawyers that work for me at all times. So, from a resource standpoint, I mean, very there's very significant resources, even at the trial court level, that I have available to myself. So in that regard, I mean, I think a lot of it, candidly, is sort of triage in the sense of, I don't know. I talked to him about, there's a lot of cases or fact patterns or, legal issues that we see frequently. And, those cases need to be dealt with accordingly. We see them frequently. We're familiar with the issues. There's no new ground that we need to go over. And so in some ways, almost encouraging that aspect of it allows for the encouragement of the aspect that you mentioned. So when something does come in that's novel, or something that comes in that requires more time, from an allocation of the time we have in our chambers, we are free to dedicate the resources that are necessary to that. And so how I instruct my clerks is that, one of the keys, and it's probably one of the keys for all of us, is we need to recognize those issues early, in litigation when we're seeing something, so that, candidly, we can treat that case differently than, say, a Social Security appeal or something. And that's not to diminish a Social Security appeal, but it's just saying that we know those issues. We almost have sort of templates of, how we can make those decisions and whatnot. So it's a little bit, it's like someone described it, a colleague with Judge Limbaugh and I described being a judge as, sort of being an air traffic controller. You are trying to guide all the planes in to land safely. And when you see one out there that's off course or having, mechanical problems, you need to focus on that one to get it in a little more than the other. So I don't know if that helps, but that's my answer.
How many students are here? Hold up your hand if you're a student here. My goodness, a good representation. Yeah. Okay? That. Now, in response to the last question, we have several distinguished United States Supreme Court clerks, Missouri Supreme Court clerks who are now judges that I see quick. How many in the room here clerked for a judge? Okay, good. Now, hold your hands up, students. Keep your hands up. Hold them higher, the clerks, if I can boss the lawyers around for a second. What I do for a living, I guess. But students, ask them about clerking. Ask them about clerking. Ask them how they got the clerkship. Ask them what they did in the clerkship. That would probably be your best use of your lunch hour, if I can be bossy. But so far it's worked for Judge Limbaugh's son and my daughter. We'll get over that. But I got it in, didn't I? Yeah, I got it in. I knew I'd get it in sometime. I do in most conversations. Okay, we're right on time. Now, let me explain. Lunch is on the second floor. The executive officers, in recognition of the Missouri Constitution, are on the second floor with the legislature on the third. So, second floor, it's the northwest corner. For those of you who went down to Secretary of State, and I've got to pause and say Ashcroft, I always say Blunt. Secretary of State Ashcroft's office is on the north. There are big stairs at that corner. There are big stairs right out to this side. There are 3 or 4 elevators around us. It should not be hard to get there. That's where lunch is. And what time do we reconvene? 1. Everyone says 1, and that's a great panel with great people on it. So be sure and be here at 1 o'clock. And with that, we're adjourned until then.